We want to welcome you this morning to this workshop of the Hidalgo County Commissioners Court, which is set for today, June 13, 2016. Present are Commissioner Cantu, Precinct 2, and myself. And the issue is discussion on various components of the design and construction of our new Hidalgo County Courthouse. What I thought we would do, instead of starting off with paragraph A, which is on the issue of insurance programs, that we would go down and talk about section B, the status of the current draft RFQ drafted and developed by the Honorable, our lawyer, Honorable John Hawkins, from the Porter Hedges Law Firm, for the procurement of program management services to assist in the new courthouse project, and as sent to Mr. Steve Crane of Addison Hall for his review. We have Mr. Crane present, we have Mr. Hawkins present, and Marty.
As it's self-explanatory, we do have a draft of the RFQ just this morning. And I did hand it to Mr. Hawkins. Mr. Crane has made a few recommendations, and that's on the second part, which is the Exhibit C. We're at a point where we want to finalize the RFQ on the program management service provider so that we can move on and get that going at the request of the court and direction of the court. So we needed to draft a little more of a general customized Exhibit C, which we usually have, and of course Mr. Hawkins had recommended that that's why they want to go into the OSIP, because they didn't feel that was sufficient, and we all agree on that. And so I think I need to know the status of Mr. Crane's review of the RFQ and any kind of consultation that they may need to do together on giving us a finalized product so that we can, I did place it on tomorrow's agenda, but we certainly could take action tomorrow if we have, subject to Mr. Crane's final review as to form, legal form only. Content is being left to Porter Hedges as to the draft itself. So,
and just to touch upon that a little bit, Marty, it's from what I've been saying the last few months, I think that the program manager needs to come on board to help assist us with a lot of these things that we're not very familiar with. And so I don't understand the rush, and we try to skip the insurance, but you brought it up. I don't really understand the rush on the insurance, and we'll get to that. But I think that first and foremost is the project manager to step in our shoes and represent us and get us to where everybody's talking the same language and we're getting everybody that we need on board.
Okay.
I'm not sure if there's a rush to get the insurance, but this is a new type of policy that we had not discussed at any time, and I don't think we've ever had a policy of global insurance.
Judge, to be correct, I mean, just for your information, it's called owners controlled insurance policy.
And Judge, just so that you know, I'm very interested in it, and I want to understand what it is. But I don't want it to delay the hiring of the project manager. That's all I'm saying. Because I saw somewhere that we have to simultaneously do these two things, and I disagree completely.
No. I think the misinformation is there. That we had to create the normal Exhibit C that goes out for every contractor we're going to get on this new project, the courthouse, to include language that would tell them what type of insurance will be expected at the time of, and this includes the program manager, at the time of negotiating the contract. So that is what since it is a component of what the program manager will need to be negotiated with, we needed to devise a new Exhibit C that would tell that potential respondent.
Are we under the understanding that this OCIP is going to include the project manager?
Every contractor.
There's no way. But go ahead.
And maybe I'm wrong.
Well,
you can correct me at any time.
Would this be a good time for me to?
Certainly.
Yes. Feel free to stand up and correct us at any time.
Thank you very much.
But before you do that, Mike, do you have copies of the draft?
Exhibit C?
We bought 3 copies. You need the draft, which one?
The RFQ. I'm going back to the RFQ, the program management.
We have a couple of copies. We're just wanting to finish the Exhibit C to be able to. There you go.
And there's Exhibit C attached to this?
We have a draft ready because it wasn't.
Do you want to give us a draft?
Oh, let me get you.
Shall I go ahead?
Yes, go ahead, please, sir.
My name is John Hawkins. I'm with Porter Hedges, the law firm that I'm afraid may have resulted in some miscommunications, and I'm happy to be here today to try to straighten things out.
So we want to thank you for making time to be here.
These are the
Hawkins.
changes.
My pleasure. Thank you, Judge.
Okay.
Let me start with the RFQ insurance, and then we can talk about the other insurance later. Part of the problem is in discussing insurance, there are all kinds of products from all different carriers at all different prices for all different types of projects. Typically, well, I shouldn't say typically, in recent years, the insurance gurus will tell you that a $100 million project is sort of the tipping point where if you can go to an owner-controlled insurance program.
Could you pick up that mic a little bit, please?
Sure. I'm sorry. Is that better?
Yes.
See if I can do this.
There we go.
How's that?
Very good.
That $100 million project is a tipping point where owner-controlled insurance programs become a better deal for you financially.
Become a benefit?
More cost-effective.
Okay.
Okay. And it's also good in that you have control to make sure that everybody has adequate insurance. Okay. Now, with that generality, let me talk specifically about the insurance requirements for the program manager. And let me do that by breaking down insurance for a project like this into 3 groups, or 3 types of policies. One policy is the builder's risk policy. That's property insurance that insures the cost of the materials and labor that are being put into the project as it is being built. Okay, and we can put that aside because that one's pretty simple. The second type is I will group together commercial general liability insurance, and that's the typical sort of insurance that contractors and subcontractors have, or in this case, a construction manager at risk. Also combined with that is workers' compensation. That's what a so-called wraparound policy generally consists of, and that's for the contractor or the cement risk and its subcontractors. And what typically happens is if they want to work on the project, they're required to be a subscriber, and often they're required to pay a part of the premium. The third type of insurance I want to talk about is professional liability insurance. Professional liability insurance is what it says. It's for the architects and the engineers and the program managers and the geotechnical engineers and those sorts of people, architects and engineers. Professional liability insurance covers these professionals. CGL insurance that a contractor would have almost universally has an exclusion for any kind of professional liability. So it's either one or the other. It's either black or it's white. And so coming back to Exhibit C for the program manager exhibit for insurance, it has some requirements that says you, as a program management firm, would be expected to have all these insurance. Chief among them is professional liability. Now, I've put $10 million. Insurance experts may tell you need more, you can do with less, but that's a substantial number. A substantial firm would have that much.
But we're also going to rely on your experience in that in projects of, let's say, between 100 and 200 million, what is the industry standard? The insurance company is going to say, we need all types of insurance, right? But we're going to have to see what the industry standard is.
I don't think there is an industry standard. and an insurance broker would be better qualified to tell you what is reasonable in terms of the cost and so forth. But I will tell you this, that lots of architects in Houston, which is my experience, who do very large, for example, hospital projects, will often have $3 to $5 million in professional liability in projects of this scale and even bigger. $5 million is typically considered a large policy. $10 million is considered a very large policy.
And we appreciate your experience. That's why we would like you to tell us those experiences that you've had in similar projects.
Okay. I think $10 million is a big number. Let me put it that way. When you get into actually buying insurance and consulting with those who that's all they do is insurance, and this is important, they deal with the insurance companies. They know, these brokers know the insurance programs and policies that are on the market that can be bought and what they cost and who they sell them to and how many they sell and for what kind of projects. I'm a lawyer. I'm not an insurance broker, but I certainly know something on the subject of insurance as it relates to construction. So, to come back to the RFQ insurance requirements, we have this $10 million professional liability requirement. That's the most important thing for the program manager. You may or may not want to have a owner-controlled insurance program policy for professional services, and here's why. You certainly should consider, after talking to a broker and seeing what it costs and so forth, having the OSIP, an owner-controlled insurance policy for the contractors. Okay, when it comes to professional liability part of it, it's a little different, and here's why. Most professional liability, they're called practice policies. It's the policies that architects and engineers have for their everyday projects. And they will keep this insurance year to year, or they'll renew it year to year. The thing about these professional policies is this. You can certainly get a group project-specific professional liability policy, and that's often done on very large projects. The problem with them is this. If I'm an architect and I'm working on a courthouse that has a project policy of professional liability insurance, my practice policy that I have every year, throughout the year, will not provide coverage, typically speaking. So you may be better off not to have a project policy for professional liability. That's, again, something that we need to consult with insurance specialists to see what products are out there and so forth. There have been instances, for example, there's one where, I won't get into specifics, it was very large.
Hold on, just so I understand that. Are you saying that the project specific would be a lesser amount or smaller or a bigger amount?
Well, let me give you this example, and I think it will answer just that very question. There was a very large professional football stadium built in this country a few years back. And the Sports Authority bought a project policy for professional liability insurance. And they had, as it turned out, $4 million in coverage for the structural engineer. There were structural engineering problems, and when it came time to call on that insurance, they found out it's $4 million. And then they turned to their regular policy, and it says, well, if there's a project policy, we provide zero coverage. And so the Sports Authority and the engineering firm ended up having less insurance than they would otherwise have had. So you have to go into this asking yourself, do you really want, I'm not trying to talk you in or into or out of a project policy for professional services, but it's a different animal. And so I think that's where you talk to your insurance professional.
We're going to want maximum coverage.
Yeah. So, I mean, I think what you're saying is that the other policy was greater, and it probably didn't. I guess it didn't have any other claims against it. So in that case, it would have been better to have gone against their regular policy.
That's
But
correct.
if 4 million is a number that we're all comfortable with, and we have project specific, I would think that that's the way we'd want to go, so that we know that there's nobody else trying to make a demand against those 4 million, let's say, we know that it's only for us and for something that happened on our project. We don't have to worry about what happened in neighboring cities or.
No, that is absolutely right, and I think there are several moving parts. That's one of them. You don't want it being depleted by claims on other claims on that policy, and that's absolutely true. You have more control over it. It's dedicated to you and so forth. There are a lot of moving parts, and you also have to look at, obviously, the cost of it.
Sure.
And is it cost effective?
So you've given us a great starting point. Just to get back, would this policy that, if we're able to get a policy for this job, would the project manager be under that policy?
Yes. Well, maybe. Typically, and I'm going to use two different terms. I think that's part of the miscommunication we've had here. Sometimes I call it a program manager, and that's what this RFQ is about. Some people call them construction managers, and that's a little bit of a confusing term. It's ambiguous. I use the term owner-controlled insurance program, and that program may have several different types of insurance. One of them is what's euphemistically called a wraparound insurance, because it wraps around a lot of different things. Your OSIP, a typical owner-controlled insurance policy, is for the construction side.
Excuse me, John.
Yes.
Are we taping this?
Yes.
Good. I don't have to write so.
So the owner-controlled insurance program may or may not choose, or you may or may not choose, to have in it professional liability. That's an option that you could consider, and it would be part of your program, but it may not be. You may choose not to have a group professional liability policy.
And just to follow up to that, so I would just think that the architect would be under, and we're going to learn more about this, but the architect would be under the OCIP, but the project manager would be outside because they're our representative, right? They have direct.
The architect, the engineer, the geotechnical engineer, the program manager would all. They'll
either be in or out. All of them would either be in or out, is what you're saying.
Yeah, that's a different group. You have to separate the contractors from the licensed professionals. Okay, and licensed professionals are insured under under professional liability insurance. Contractors are insured under commercial general liability or CGL policies. CGL policies say we will not cover any professional liability. Now, oddly, in every contract I've ever seen, there's a requirement that the architect and engineer and program manager carry CGL insurance, including here. It really doesn't cover very much. It might cover if you go into their office and slip on a watery spot, okay? But when it comes to the designs they're producing, the CGL policy will not, generally speaking, provide any coverage for professional errors and omissions.
So then if you're saying that we may have a policy for the contractor and separate policies for the designers, why do we need an OCIP? Why don't you just get commercial, general, your normal insurance?
Well, let's talk about the owner-controlled insurance policy, the OSIP, for the contractors. One of the reasons you do that is that on projects of this scale, it's often cheaper than relying on all of the various contractors to provide their own, who, of course, in their bid are going to include some cost for the insurance they carry.
So we have ABC Company, I'm sorry, but if we have ABC Company as a contractor, you're talking about the subs having various policies?
Yes.
Okay.
So each will have subs. subs that you're going to deal with on a project of this scale will have their own insurance. This construction manager at risk will have its own insurance. What the OSIP will do is supplement that insurance, and it will be the primary insurance, and you control it. You control its limits, and therefore you make sure you have enough insurance for construction-related things going wrong. And the brokers of the world will tell you that at some size of project, it's cheaper for you. Let's face it, at the end of the day, whether it's the subcontractor or the CM at risk markup for insurance, even if that's the way it is, you're going to pay for it. If you buy the OSIP, certainly you're going to pay for it. And often the way it's done is you say, subcontractor, you can participate on this project because we like your bid, but you're going to have to enroll in the OSIP, and you're going to have to pay some of the premium. So at the end of the day, the county's going to pay it one way or the other. You just want it to be a lesser amount.
Okay.
Now, I got way off track. We were going to start with the RFQ, but
Let's get back on it then.
okay. I want to apologize that I sent, when I prepared what I prepared, I sent 2 documents. One document was in clean form that did not show the changes I made. The other one that had all the red and blue, all it was meant to do is to show what I changed in the RFQ for the construction manager pool. Okay. I understand that what you have now is the clean version of what I sent that has everything I put in it. Where should I start, Judge? Would you like me to go over the things that I changed, the principal things?
Commissioner?
No? Let's see. Ready, golf, Judge, if you have something, go for it.
Well, maybe he could go over it by section. We could start with legal notices and just go by the different exhibits and sections that we have.
Sure, I'd be happy to.
Cover letter, I don't think is a big deal.
I've gone over it, so I don't know if the judge needs that detail. I'll sit through this, but I hadn't seen Exhibit C.
No, because that was.
Is that specifically for insurance?
That's
Okay,
specific
so we can
to
save that
insurance.
for the insurance conversation.
Right, but it would also be part. Would it not be? Would it also be part of the RFQ?
It will absolutely be part of the
It would
RFQ.
be part of the RFQ, Commissioner, so that we can move on, because that was incomplete.
Okay,
That's what we were just talking
One
about that
question-
started.
One question that I will have.
but it looks real insurance related.
One of the questions I do have, and I haven't spoken back with Mr. Crane about it, was the Davis-Bacon provision.
We need it in there.
We put it back in, because as I explained, and that's something that Mr. Hawkins may not have been aware of, a lot of jurisdictions have their own staff that assists in complying with Davis-Bacon. The county never has. It's relied on its contractor, on its professional service provider. So we put that back in because he had removed it. I know I don't know if Mr. Crane has any other major
I don't have any major
observations.
changes other than Exhibit C.
Right. Exhibit C
And
was not
comments
there.
about the need for something else regarding
Right.
Exhibit
He
C.
expanded it. That's what you've got. And so and I think Mr. Hawkins did read it. We provided it
And
to
then
him this morning.
If maybe after me, just
Yeah, there's a few more nits I want to.
Mike, let me know.
Right.
We can have a copy of Exhibit C.
That's Exhibit C.
I know, but it's not mine.
Oh,
Oh,
I
it's
provided yours.
ours. You can
Here
have
we
it,
go.
Judge.
And Judge, Commissioner, when you're ready, I do have a few comments with regard to
There you go.
Thank you.
Exhibit C as a whole, not what you have in front of you.
Well, then, should we go through the RFQ first and then get to the exhibit?
Your pleasure.
Okay. Marty, just minor things like the RFQ number on the first page, is that the correct RFQ number? And if so, can you drag it throughout the document?
Oh, no, we
the
will
document?
assign a number. We have
Okay.
not assigned a number. That's just RFQ for 2016. It's going to be a number in front of it.
I don't have a comment till page 5, additional information required. since all the money that we're using is not state or federal money, do we need DBEs or MWBEs? Is that standard for us to have those? It's the last bullet point in B.
I'm sorry, what page you're on, sir?
Page 5.
Of the legal notice? Or what?
It's a state
Maybe it's Exhibit A?
firm qualifications.
Oh, that's under probably Exhibit A.
Here it goes. I'll get you
That's 5 of 9.
there. No. Firm qualifications. I didn't have any comments to that.
Under what section?
Page 5, not where it's of 9, it's just page 5. So it's probably about 15.
Oh, right here. Okay, page 5. And it's what, B you said, qualifications?
Under
Right.
additional information required, the last bullet under B.
The last bullet.
Under B, statement regarding achievement of, well, this is minority women's business enterprises. That's just federal requirements, either hubs or.
But we don't have federal money on this.
Well,
Right, but it's standard, which shows our willingness and encouraging participation by all those types of businesses.
But is it too limiting? Should it just be a DBE?
Well, throughout your body, I think we're going to be making I think it's in the legal notices, we make general statements about historically underutilized businesses and those types.
But this is limiting it to MWBEs, or no?
No, you can we can add, but we could also add.
Could you just change it to DBE, which is all minority?
All right.
I mean, so
Doing
that you're not
business-
having such a limited.
Okay, make that a little broader.
Yeah.
Okay.
And that's standard for these, Steve?
and most of the ones we use, MWBE is standard. I think, Marty, in all the ones you've done, you've used MWBE.
We use MWBE. We also use the HUB, the hub. We also use one more designation. I can't think of it right now.
Is that going to limit us at all?
No, not at all. Like I said, I can expand it to include hub and all other
Okay,
minority-owned businesses.
that's not a big deal. And then page 8.
Okay. Deliverables.
Yeah, it's Y. No, above it in Y.
Why?
It talks about some of the work the CMAR.
It's going to be doing?
I mean,
Yes.
it's what the project manager is going to do with the CMAR. And it talks about, in the middle of it says, let me get the judge here. Hold on.
I got it.
You got it, Judge?
I don't know where you're reading, but I got that
I'm going
paragraph.
to get you right here.
Page 8.
starting here.
The same section you were in.
And then I'll have another comment similar, right? It says, work with architects to assist in monitoring the quality of work being performed, ensure that the CMAR maintains the quality expected, as well as provide any corrective action required for any identified deficiencies. Monitor the activities of all testings. I just want to make sure, and so I have another comment later, that the program manager is not really part of the design team. The design team is going to be the architect and then the contractor, or the contractor handling the architectural services themselves, but the project manager isn't going to be a part of the design team. Just want to make that, separate them.
But he's going to be
Overlooking
inspecting
or
or supervising, or maybe not supervising, that's not the proper term.
Observing and being made aware of
What would the proper term be, John? We don't want to make him liable for the work, but we want to make him liable for looking at the work and reporting back to us and concluding and opining that it's good work.
One of the things that the program manager can do, because you can buy all different sorts of options, but generally speaking, they will be involved, to answer your question, in the design, as an advisor, but more as your eyes and ears, you the owner. Okay. Once you get into construction, under architects and engineers terms, that's called the contract administration phase. And typically, if you get full architectural services, one of the things that the architect will do is to make periodic, often once a week, once every other week, site visits to go around and inspect the work. Typically, with a program manager, you will have a full-time person on site who will do a lot of different things, but one of them is to be on the site every day to watch the quality of the construction.
And that's what I'm expecting from the program manager, whatever you want to call it. But do we need that part of the? Do we need that part? Do they need to be actually giving input on the design?
Commissioner, if
Yes.
I may point out one thing. In that same paragraph, if you look at the bolded language, it says the program manager shall not interfere with or take on any control over any construction means, methods, sequences, techniques, or safety programs of the CMAR or its subcontractors or suppliers.
So it's limiting it.
That provision limits everything else he can
So
do.
what is the standard of care that the PM has?
The PM has a standard of care to go out and look at the project, not get involved and tell the contractor how to fix something, but to go tell the contractor, you built this wrong, go fix it. And the standard of care is to use the ordinary skill in being diligent and going out and finding any problems there are and getting it fixed. If you were building a house, it's the same sort of thing. You go out there, you're not responsible if they build it wrong, but you want to see if something is built wrong. And the standard of care relates to the obligation of the program manager and the architect, for that matter, to pick up on problems. Does that answer your question, sir?
And Judge, you can raise that standard through negotiation with the PM.
You can. One of the things that you'll have to consider if you raise the standard of care is whether or not it's an insurable standard of
Correct.
care. I think
Does
that's
any
an
of
important consideration.
does any of this change if the CMAR team brings in their own designer?
Oh, no.
It's the same thing. Okay.
No. They're there to cooperate and administer, I think that's the word I would use, administer what all the stakeholders, the architects, engineers, the contractors, the subs are doing to make sure everybody's doing their job.
If by looking at it and observing it's something, a defect that's so obvious that it should have been picked up, I mean, that's a kind of standard that
That would
I'm
probably be,
envisioning.
yeah, they would be subject to a breach of the standard of care.
Okay.
If, for example, after the building's finished, it turns out that the fire stairs don't meet code, then the architect would be called into question because maybe it was designed wrong. The contractor might be called into question because it was built wrong, but the program manager might also be called to court because the program manager should have caught that before the building was completed.
But the program manager owes no duty or obligation to the CMAR or anyone else.
That is correct.
Only to the court.
That is correct. It's one of the checks and balances that you have. The PM's sole obligations are to the county. They're there to protect the county, period. Well, I'll say period, in addition to assisting with the project and so forth. But their duty of loyalty legally and practically is owed to the county.
And I guess, I don't know if we addressed it in those comments on page 11, number 3, experience and availability. Minimum qualifications, the respondent must have been PM for 2 different types of projects and must have been personally involved with 50% of the technical development of projects.
Yes, and I believe that is Forgive me, I can't remember all this, but I believe that was a requirement in your pool RFQ.
And the 50%, would we be able to quantify that?
Well, I think that would just be a requirement. They would need to, let me make sure you're under number 3.
3, yeah, and then
Yes.
minimum qualifications and preferred qualifications.
Well, they would have to come before you and make that statement, and hopefully they're telling the truth, that and demonstrate to you that they have that qualification.
But so then where it says 50% of the technical development, the project manager is going to be involved in the technical development?
No, of the technical aspects of what a program manager does, not
the design.
No, not the design nor the construction. There are a lot of very specialized technical things that program managers do in terms of how they monitor the construction and the design process to make sure it's getting done.
Do you envision this program manager to have on staff or to have professionals available that they can consult with when they're overseeing the work that's being done by some of these other parties?
I don't want to overgeneralize, but quite often, and maybe even more often than not, program managers are architects and engineers. And this is just the type of work that they happen to do.
And so they're going to have a lot of people that have expertise in different areas of construction.
Yes, sir. They certainly should.
Right.
While they deal mostly, and this is another gross overgeneralization, but they deal in spreadsheets and schedules and that sort of thing, quite frequently the people who are doing that, who are employed by the program manager, are in fact architects or engineers. So they're familiar with
And
what's
it's a
going on.
huge
Or
group.
contractors as well.
It's a big group with a lot of different expertise.
That's correct. And how much is enough, that would be part of the qualification process that you gentlemen get to make a decision on.
And then the respondent, the next one, respondent must, I'm trying to see what we're trying to accomplish here. The respondent must have been PM for 5 different types of projects and must have been 85 to 100% involved with the technical development of the projects. What do we want to do? What are we trying to accomplish there with 5 different types of projects?
Well, we can argue about whether it should be 1, 3, 5, or 10. Okay, 5. I'm not sure if that was the number in the pool or not, or if that was a number that I thought seemed appropriate. But that's certainly open to debate. I mean, how much is enough?
What's a different type? What would be, if you had 2, what's 2 different types of projects in your mind?
A hospital, an airport, a courthouse, a school system. Those would be.
Well, I'm sure that that's going to be.
I don't think that you're going to find in the state of Texas
If they're
a
experienced.
program manager.
Yeah.
Well, I mean, I just wanted to make sure.
There aren't that many courthouses built in the state. I don't think there's going to be a great depth of program managers who do nothing but courthouses.
Do we have any preference set out anywhere for people from Hidalgo County, or for them to hire a percentage from Hidalgo County in
I
terms
did
of
not put that
engineers
in
and
there.
architects and
No,
stuff?
sir. I think that would be a question for legal counsel and the people who are more versed in whether that's appropriate. I mean, certainly it's appropriate for you to think about it, and then the question is, in a procurement sense, whether that's something you want to do.
But you've seen that in Houston, haven't you? I mean,
Yes.
that's standard. Whether it's Houston, and I said Houston because you're from
Well,
Houston.
I don't want to say it's standard. I will say that because I don't know one way or the other what's standard, but it's often the case where people give preference. One of the criteria is to give preference to locals.
Well, I would give preference to locals. I mean, if they can do the job and they're here locally, I mean, that has to be very important. Where would we put that, Marty? Where do we normally put that?
We could probably put it, well, it's probably not under the criteria. Is that where we're at?
We're experiencing availability.
What I can do is I can share with Mr. Hawkins and with Mr. Crane. I'll get it off my list server on other jurisdictions and the general language they've used. And
But I'm sure we've used it.
well, we can encourage local, there is such a technical term, it's local preference. But in local preference, a lot of times, you have to set a standard of how much that local preference can be. 50% of the, it's going to have
minimum. You have to set
we
a
can set a
minimum.
minimum.
Right.
Can you tell us your experience? And I know that there was one time when you told us that we could not dictate that they hire local people, but we could strongly suggest
Well, the word preference, I
Well,
think, is the main
Let me
operative.
answer the question this way. What you're looking at, Judge and Commissioners, right now is the point criteria to evaluate and score the various proposals that come in. And so I think you've got two sub-questions in this is local preference we use a lot for the day-to-day projects. But a $100 to $200 million project is not a day-to-day project. So I think what you've got to look at is when you get down to the qualifications of each proposer, if you want to give some points for local, then you reallocate your point system here, and I would recommend a minimum amount of points for local because you want to make sure that the major point of the evaluation scale is a proposer who has the ability and qualifications you're looking for a $100 to $200 million project. Then you could put some minor points in there for local, but that's a decision the court has to make because it's a compare and contrast situation. You want somebody with the best experience you can get, but you'd also like them to have some type of local presence. So that's where it's a scale. Y'all got to decide how many points you want to allocate for local versus I don't think you want to take all local, for example, and discount the quality and experience of a provider who is not local. Does that make sense?
So maybe it could be a
Well,
determining
we've already
factor.
done it in the architect. Obviously, we got somebody that had courthouse experience. They weren't from here, and so, I mean, obviously that's very important. But we also have both of them presenting to us, bringing in local people because there's some stuff that even the locals that don't have courthouse experience can do.
But on the project manager, what you also have to consider, I believe, and Mr. Hawkins, correct me if I'm wrong, is on the project manager, that is your eyes and ears on the project. You want somebody totally loyal looking to you, and it's your person, to watch over every other professional and contractor involved in the project and making sure that they've got the experience both on the design side and on the construction side, that your eyes and ears out there watching over everyone else who's involved in the project.
So what are you trying to say?
I'm saying this, to me, this person is, the project manager is probably, from the owner's standpoint, your reliance on watching out over all the design professionals and the construction contractors to be your eyes and ears, as if, I'll use Mr. Hawkins' example, if you're building a house, okay, and I remember as a kid, my dad built our house where I lived, and he would go out there every afternoon before the sunset to look at everything that had been done, and he discovered all kinds of things, and he wasn't a professional and he wasn't a contractor, but he could read plans. He would find out the studs were not placed at according to the plans, the proper distances, the electrical, those plans specify, for example, copper wiring. He found out they were putting aluminum wiring. You have them tear that out. I'm just saying there's all kinds of examples of you want your eyes and ears on the ground watching the design and the construction to make sure it complies with the plans that are drawn and is the best construction practice in building the project.
But I think we
How
all
could
we
we-
all agree with that, Steve.
Could
But
we
the-
incorporate, may I suggest, maybe, as opposed to, maybe a determining factor may be that they are from Hidalgo County, but make it a small 0.5, maybe, make
I'm
it
saying
possibly
that way,
105.
if they are local, they do get a small bump. I think that's what I'm saying.
Yes,
Oh,
so
sure.
let's say, let's
I'm
say
saying not a
5
major bump, but
Yeah.
a small bump.
Of course.
local presence or
But
local,
just to on Steve's point, I agree with you, Steve. But you want to have the best design and the best contractor so that you don't have a project manager looking at so many issues. So the priority is the designer and the contractor. Obviously, project manager is important, but if you hired the wrong architect and the wrong contractor, I mean, you're in a world of hurt.
And how are you going to know if you hired the wrong architect or wrong contractor until you've got somebody out there on the project looking to see whether the
Well, you
architect-
hire the right one because you hire based on experience and them not
Demonstrated
having
competence.
lawsuits filed against them and having good experience with their owners.
But in my experience, I don't care who the contractor is or who the professional is, there are going to be things that are overlooked, and you need somebody out there that's your person that can read plans and can look at what they've done and determine are they following the plans. That's the only thing I'm saying. You need your own eyes and ears out there.
I agree 100%.
so would you want to establish perhaps 105-point criteria, 5 points being the local,
For
the
local.
local presence?
Yeah, that's the decision they need to make is how many
That's what I'm
points to
saying.
allocate to.
That's
Sure, that's fine.
one other way to address what Commissioner is looking for.
That would be appropriate. I think I would also make the bidder aware that we're interested in them, if possible.
It'll encourage your locals.
Right.
So we could add that? Is
That's fine.
5 points
That'll be fine with me.
agreeable? Okay.
Yes.
So that we don't lose focus on the 100
Sure.
points. Okay. Oh, and that's one thing that Mr. Hawkins is going to finish the actual scoring sheet that will address this. So we will look for language we may have had in other projects we've done here locally that give us the additional 5 points. I'll try to get that to you.
Right, just to reiterate that, I didn't see any point in doing the score sheet until you knew what you were scoring.
Right. Well, it's because
Or
it's
how
going
you-
out. It's going out tomorrow, so I just wanted to make as many comments as possible. The RFQ is.
Any other concerns, Commissioner?
No, not on that. Well, no,
Not on the RFP?
no, sir.
Commissioner, just as additional, I think TxDOT also has language in there for local preference. So we could use that language. I mean, if Mr. Hawkins and Mr. Crane think it's appropriate, we'll generalize it. But
Right.
TxDOT does have some language toward that.
Okay.
Doesn't look like that's come up. Oh, that's right. The questions you had recommended on that commissioning factor. Yeah. There was one other point that Mr. Hawkins and I think Mr. Payton had weighed in, that they were discussing commissioning in general. That is a service that involves the PM more deeply into the project from design all the way through system startup and operation. Commissioning is not included in this draft. We wanted you to be aware that it's an option, although expensive. So I'll let him talk about what commissioning is on the PM side. It's not included.
Thank you. And let me say, it's not included expressly. A lot of the requirements that are in Exhibit A cross over into some things that, if you get commissioning, would be done. Full commissioning, though, is a higher level of involvement, and it's a longer level of involvement, and of course it's going to cost more. Let me give you, I think, one of the better examples to explain what commissioning is. If this building is going to have, are you familiar with LEED designations? You know, silver, gold, platinum, which has to do with environmentally friendly, energy efficient, and that sort of thing. And there are standards and points and so forth. And I'm sure your architects will recommend that you get a LEED designation. Okay, so let's say that you've decided to go for LEED Gold. One of the things you have to do, there's a criteria of things that are built into the design that will, and it's given a point system that will give you the opportunity to have a LEED design. Okay, but to get the LEED design, the building, they don't come for the final inspection until a year after the building has been running, because you may pay for a very expensive, highly energy efficient cooling system for your air conditioning, but they want to come back a year later to make sure it's been run right, and it is running right, and you are in fact saving substantial amounts of electricity. What the commissioning expert will do is get involved in the design to make sure that or to monitor and administer, perhaps, whether the design team is including things in the design that will get the LEED points. But so they dig a little deeper. On top of that, they stay around longer to make sure that once the building's up and running, that the people who run it understand how to run the systems, that the systems get started up correctly, and that they continue to run. And so even though the architect and contractor are out of the picture now, the commissioning services would continue through the operation of the building to some point.
Any idea how much more that would cost?
I really can't say, and I think that's going to be, I think that's something that it's going to depend on who's doing it as to how much it's going to cost. It will cost more, for sure, just because it's more work.
Any other matter you want to discuss on that section B?
Judge, in light of what he just explained, would you want it written in as an option for the PM respondents to know that it may be something that Hidalgo County would consider, and then at the negotiation, it gives you all time, and at the point of negotiation, it may be something you would like to discuss.
So they'll be aware of it at the time they're bidding.
So that they're aware that it's an option, strictly at the discretion of Hidalgo County, obviously, but it may make them aware of what the role would be, and even after occupancy of the facility. So if you would like for him to at least write some language that it's a possibility, that it is an option.
Sure, as an option.
I think it's
For sure.
It's prudent to do so. That would be another item.
Have we covered that section B fully?
I think so, sir.
All right.
In my mind,
do you have
I'd be
any
happy
other
to answer
issues on section B?
On the scoring? I guess just since you're here, why are you recommending CMAR versus the conventional or design build? Just to kind of give an overview.
I think the industry would tell you that CM at risk has a greater opportunity to succeed and meet your goals. One of the primary advantages of CM at risk is that you're selecting the contractor, if you will, if I can call the construction manager a contractor, the person who would have been a general contractor, to get involved in the design. And that's really important because the architects design buildings, but they're not construction specialists. And the contractor can come in while the design's going on and say, you can do this and we'll make it look this particular way, but we can use a different construction technique. You get the look you want and you'll save money. Okay, that's one of the chief reasons to do so. The other delivery method that usually comes along with a CM at risk is that, well, a couple of things. One is, as the plans develop, even before you get, well before you get to the full construction documents, the CM at risk will take those plans and put them out to bid to the subcontractors. And you get the feedback while it's still not too late to change the design. It's not like you get all the way through the construction documents, then put it out to bid, and then find out, oops, we've spent more money than we have. Another feature of CM at risk that also, you don't have to do it this way, but I think it's probably the most frequent, is to have a contract that's called cost plus with the guaranteed maximum price. And that is the county pays for everything that goes, all the labor, material, equipment, and so forth that goes into the project, plus overhead and profit for the CM at risk. So you're getting things at their cost. It's more transparent. You know exactly what the CM at risk is making on that, plus they get a percentage add-on for their trouble, of course. And you also have a guaranteed maximum price. And when you take the partially completed plans, and you can do this at different, you can choose at what point in time you do that. Often it's done at the end of design development. You put it out, and then the CM at risk will come back and say, this is my guaranteed maximum price. If the project goes over this price, it comes out of my pocket.
But I think we want to figure out the GMP as soon as possible in the process, because if we go all the way to the end of the design, that means we're going to have spent $8 million or whatever the architectural fee is. And then at that point, we're almost stuck to what they designed, and we may be at, $200 million. So what's the fastest way we can get a contractor to give us a GMP, and then we can focus all our efforts on keeping it at that GMP?
It's a balancing act. There's no hard place because, as you point out, you don't want to get to the end of the construction documents to start that process, because then you're just doing what a design, bid, build, linear program is. On the other hand, you want the drawings to have enough information in them that you can get accurate pricing. And so a lot of times in the architect's services, you have schematic design, then you have design development, and then you have the construction documents phase. Frequently, the GMP will be established at the end of the design development phase and before construction documents start.
Which in ours is what percentage is that, Marty, do you know? Design development? Like we've done, 5 or 10% at this point? On the percentage breakdown.
Mike?
I'll give it to you in just a minute.
Sure, that's fine. Sure. Judge, I just don't want to get too far along where we spent all this money and we're at a number where we can't do anything about it at that point.
Hello, John Neeson with HDR. The way we design buildings this day using Revit software, DD is much farther in the process, so we have a good handle on what the building is going to look like. So to answer your question, how far is that in terms of percentage complete? We're roughly 55 to 60% complete.
Right now, where are we?
Right now,
percentage.
15 to 20%.
So you're saying that we wouldn't have enough information to get a GMP till 55%?
If you want the GMP at the end of DD.
No. Where would you think that we could get a GMP? At what percentage?
Well, like Mr. Hawkins said, you can get it wherever you want it. But the best, it's been proven that the best place to do it and have the least amount of risk for the end of the process is at the end of the DD phase. So we are suggesting to go with what he said at the end of DD. I agree with that.
At the end of what, sir?
Design development. We abbreviated DD.
May I add something?
Sure, please.
Thank you. And I think we're on the same page about this. Probably the most important factor in picking where you are in the design process to get your guaranteed maximum price. Certainly you would consult with the design professionals, but you also need to consult with your construction manager at risk. They know, based on their construction experience, when plans are complete enough, in their view, to get accurate pricing. As I say, and I think we agree on this, it's a balancing act. You've just got to pick some logical point in time. The most common that I see is at the end of design development. Then that leaves you the entire construction document process to make changes to get the cost and so forth in line.
Have you seen where the construction manager at risk, when they handle the design themselves, do they get to that number quicker? Or would it be the same?
I'm not sure what you mean by handle the design themselves. There's a process called design build. If that's
But can't a construction manager at risk have his own architect that they work with?
That's really a different delivery system. And the way I understand what you're describing is there's a single source and you hire the contractor who also hires the designer. That's a different system called design build. And
no, I was under the understanding that CMAR has, because we've talked to Mr. Payne about it, in that sometimes a CMAR brings in its own designer, and sometimes the county, or in this case the owner, hires the designer separate.
In the CMAR, the way I understand it, Commissioner, we hired the architect like we have. In the design build, they bring in their own architect. We don't have the option of hiring the architect.
No, the statute does not permit it.
Permit what?
Under the CMAR.
Does not permit what, Marty?
The hiring of, now, I may be misunderstanding what Commissioner says, but a CMAR cannot hire or become also the lead architect within the CMAR. That is, if you read the statute under CMAR, the very first thing it says, before they're hired, the county is required to select the architect. Now, that they may have architects on staff to interpret the design of the architect of record to assist them better, to make recommendations or better assist in finding ways to improve the design, that may be another issue. But no, he cannot be also the architect. I think I had sent that out to the judge's office and all the members of the court.
I think I'm done, Judge.
Yeah, okay. All right, then why don't we go back and start talking about Section A.
May I just ask a question? I do have the item on tomorrow.
Yes.
Given the last things that are being tweaked, I think it would probably be most appropriate if, I believe we do have an agenda on the 21st, to have the completed document with all the review, so that we could have it approved by you for the advertising. I don't think we can have it already tomorrow.
Marty, if I can just interrupt there for a second. Judge, and Commissioner, can we skip to Exhibit C, the insurance?
Sure.
And we're going to come back to what Marty just asked.
Okay, all right.
Let me tell you just what I and we, when I say I, includes the firm, have found out with respect to the insurance. There are pros and cons to both the traditional method and the OSIP. There are definitely pros and cons to both. One example I'll give is one of our clients who is a contractor who does very large projects. And I spoke to that contractor, and he told me some stories about past projects he's been involved with as far as an OSIP. One project was that they were 7 months into construction before they found out that the OSIP did not have completed operations insurance. The only point I'm making with this is, as we discussed, insurance, which is a major component of any design or construction of a $100 to $200 million facility, it's a major component. And the first question most owners ask themselves, either using a traditional method or the OSIP, is the amount of insurance needed. Okay, that's the first question, the first hurdle you have to jump over. Then you go into other more technical aspects of the traditional method versus the OSIP. And without going into all those technicalities, what we have been looking for, and I'm still waiting on text, is a consultant with respect to insurance for these type of projects. And the limiting factor we put on our looking for consultants is the to qualify for the exemption under the local government code, a person, number one, who does not sell these products. So you're getting, I think, a more fair, objective look at the products. And number two, a person who we could contract with under personal services that has the experience and qualifications, but we contract with an individual to fall under the exception in the local government code. And we think there's 2 or 3 in the state of Texas that might qualify. And I'm waiting for a text, hopefully this morning, to tell me the names of those 2 people. So there's 2 things in our analysis. One, a person with the expertise in this area who does not sell the insurance product. And number 2, a person that would agree to contract between the county and themselves individually. That way we meet the requirement for exemption under the local government code. But I do think this is a serious issue as far as deciding which way you're going on insurance, and 2, and the qualifications of that expert to advise the county as what should be in the insurance products you're acquiring. And that is a short explanation of what we've been looking at.
But that's on the insurance, right?
That's
the project manager is moving forward, or you're going to wait on the insurance?
Well, the question we've got is, can we modify Exhibit C? And we've started to work on that to advise the program manager that at this point in time the county has not chosen which method we're going through, but then giving them enough information so they can adequately see, depending on which track we go, what's going to be required. The only problem with Exhibit C, if you do go the traditional method, are these individual dollar amounts, the correct dollar amounts that the court wants to use. And it's a risk analysis of the correct dollar amounts of insurance required if you go the traditional method. That's the one other thing we don't know is for a project this size, or at least I don't know for a project this size, and really you're the only ones who can answer it, are those the correct dollar limits for this type of project? And again, some of these people, well,
when you say you're the ones that can answer it, that's what we're going to be looking towards.
To the consultant. I think we're
Right.
looking towards a consultant.
And the attorneys for their experience.
and then the experience of which method for the county is best. Now, under the OSIP, what usually happens, and I'll defer to people with more experience than us in these type of projects, but when I said there's pros and cons to each, there are. And that's why I think in order to make the decision ultimately of which track you go down is you need somebody with the experience to tell you the pros and cons of each and what they would recommend, the traditional method or the OSIP, and if so, the design of the requirements for the OSIP and the traditional method.
So you're still thinking that there's going to be an OSIP for the professionals,
I'm saying that
including the project manager?
I'm
I
still
disagree.
thinking that's a possibility, but I can't answer what is best until we get somebody with the experience and qualifications to advise the Commissioners Court in their recommendation on this size project what they believe is the best type of insurance.
You're going to delay the hiring of the project manager 3 months.
Potentially, no. If we can get a consultant in just to look at the dollar amount of the project and look at the insurance, if we can get that consultant contracted next Commissioners Court meeting, I think the consultant could have answers to you in a week to 10 days.
Is this the kind of service that can be exempted?
That's why I'm saying if we can find a consultant that we can contract individually with, we can exempt it under the local government code.
Okay.
I'm just thinking from, if you file a lawsuit, if the architect fails to put something in, right? They were supposed to put in an 8-inch requirement, they put a 6-inch requirement. I mean, we're going to sue the architect for not doing it correctly.
But then in construction projects,
And then we're going to sue the project manager for not catching it. But I can't imagine them being under the same policy. I mean, the project manager represents us, and architect, that doesn't make sense.
but the project manager though is working with the design professional and looking at things. That paragraph you pointed out, Commissioner, in the RFQ, they have limited control, but they also, the question becomes for the project manager, is that something the project manager should have caught before it was put into the plans or omitted from the plans?
And so you're going to have the architect saying you should have caught it?
You're going
No,
to
you
have
should have
in a
designed
typical
it right.
construction project, when it gets to litigation, you're going to, just a simple project, you're going to have the architect and contractor pointing the finger at each other that it wasn't my fault.
That's
it
why
was
you
your
have the
fault.
project manager.
And that just adds more people in there pointing their fingers at each other.
But I think usually the architect and the contractor are the ones fighting the most, and the project manager can represent your interests, us the owners, and they can kind of get in there and
Do you want to address that one?
It's hard to generalize about
Right.
what
Sure,
might
of
happen.
course.
But I will say this, that if it were a question of whether the architect required widgets in the building or whether the contractor forgot to put them in there or the program manager didn't catch the fact that they weren't in there, I think the county would sue all three of them.
I agree. But so I just think that the project manager would have his own insurance separate and apart from the other professionals.
These wraparound policies, I'll use that general term because, as I mentioned, the professional policy is typically a separate policy from the OSIP for the contractors. You will have one policy that covers everybody, but in a lawsuit, one insurance company. And in the lawsuit, though, all the different parties have different lawyers, and they're fighting each other. But at the end of the day, it's going to be that one insurance policy that's going to pay for whoever.
What amount of policy does your experience tell you we should require in our project?
Judge, I think that's best left to an insurance professional who can find the right balance between cost and risk. And I think the idea of finding a broker, for lack of a better term, to guide you in the limits you want and whether this policy is right for this project or not, or this type of policy, I think that's absolutely the way to go. And I also think, in my experience, that these sorts of questions are not hard to answer for those types of professionals. I think they could answer those questions very readily. And at the end of the day, I guess you're going to have to answer the question, but they can tell you the pros and cons in a way that will make your decision something you can do right away.
I'm beginning to think that we're better off requiring individual policies.
Well, that could be, and
We could put together and stack up more coverage if we require that the policy not be depleted. I mean, project specific. That policy that they come in with will be only to cover us in the construction of the courthouse, and possibly get us there involved as a named insured, so we don't have any coverage problems. I mean, my experience, I sued a contractor several contractors, I guess. But one that stands out is a $28 million school. And the contractor that I sued had a $25 million policy. The architect had a $5 million. The engineer had either 5 or 1. But I remember we were dealing with about $30-something million in coverage on the issue. And then the general contractor joined several of the subs, and they each had 500,000, or some of them may have had $1 million, et cetera, where it was a lot easier to get the matter resolved because there was more than one adjuster at the table, and it was a lot easier to twist arms and get a fair figure. And I've had that experience in several cases.
I think I certainly understand what you're saying. I think that's why it would be helpful to have an advisor like this who can tell you some of the pros and cons, obviously, many of which you know from your legal experience. And that's why I think it's certainly a good question whether you want a team policy for the professional liability, because you cannot be named as an additional insured on professional liability policies. And all the defense money comes off of the limit. And if they have another claim in another lawsuit, that reduces the limit. So I think those are all questions.
Not if it's project specific.
In project specific, it only covers that one project, so you don't have to worry about some other claim reducing the limits.
Right.
Let me also say that, as I understand it, the two architecture firms whose names are before you are HDR and HOK. Although I do represent HOK in other matters, I will tell you I don't know anything about their insurance coverage, but I suspect that both of those firms have very substantial insurance, much more than you would have in the more typical size firm. So to your point, Judge, you may be absolutely right. You may have more insurance if you don't have a team policy.
But I think we should, though, talk about it with an insurance broker.
Yes, I agree.
On the project manager too.
Yeah.
I just think we need to get that person on board, or that company. But
The insurance. How can we go about hiring that insurance broker so
Well,
that we can get his opinion on this thing?
Let me first clarify that what we're recommending is not a broker. We're representing somebody who's in the industry as a consultant who doesn't sell the product.
I'm mistaken.
And so what we would do is, once we find out, I'm hoping to bring at least 2 names of people in Texas that do this. Once we find out who those 2 names are, we would recommend that you look at their qualifications, and then we would claim the exemption for personal and professional services and contract with an individual.
So we can get it done by the 21st meeting?
Correct.
Well, that's not that long.
yeah,
Okay. questions?
I don't, Judge.
Is there anything you'd like to add for purposes of our discussion here?
No, Your Honor. I'll be happy to answer any questions, but
Okay.
that's all I have. Thank you.
Marty?
So that I can be clear then the general Exhibit C would not be applicable right now to complete the RFQ. So we would wait to have that ready once they've received
Once
some-
they're under contract and the
With the
personal
consultant.
professional exemption consultant.
Correct. So that we could then finalize it and present it and ready to go to advertising.
Correct.
Are
Okay,
you
I
saying
just
we
want-
have to wait to hire the program manager until after we hire the insurance consultant?
Well, in order to put out the RFP, you need Exhibit C to the RFP to be put in the RFP. The consultant is the one that we're recommending that we contract with first to
Okay.
develop the Exhibit C.
Yes, and finalize that Exhibit C.
And you can still have an OCIP for the contractor, an OCIP for the professionals, and the project manager sitting alone with his own insurance.
You could. The only thing I'm saying is I do not have the expertise to advise you of whether that is the best way to go. That's why I'm recommending the consultant.
I just want to make that clear because I think that that's perfectly clear to me that you can have all those
No, you
variations
can't.
and
I'm just saying,
hybrids
but
and
how does
stuff.
the insurance interact of these different parties all together? And that's why I think we need the expertise of an insurance consultant.
Can we get everything done by the 21st, Marty?
Well, hopefully, we've got two candidates. On the
Hopefully.
21st, though, I can have as much of the PM ready just to, once you hire them on the 21st, he's got to give us some kind of consulting service. And so Exhibit C would be the last component before we get authority to advertise. Now, I don't know if we're going to have anything on the 28th, so that at that point it could be done, or it would be the first week in July. So all the other changes that we agreed to, additions and deletions, those can be ongoing. So the only component that would be left that would preclude us or prevent us from advertising to have a packet ready would be the insurance, the Exhibit C.
Okay.
But we'll continue to work on it
All right, well, let's try to get something done.
by the 21st
By the
on your
21st.
consultant.
Correct.
I'll place that agenda item.
Did
I
not-
mean, hopefully, we're going to have a candidate to do that.
Is there anyone that has any questions? Commissioner, Steve, Marty,
No, sir?
anyone else? All right, well, there being none, we don't have a quorum, so we don't need to adjourn. We just consider this meeting to be closed.
Thank you.
Thank you.